Well, in a landmark ruling, the Constitutional Court today ordered Parliament to amend certain pieces of legislation to allow personal use of marijuana at home. Kathy is going to explore that with a legal expert. Kathy?
All right, thanks for that, Vuyo. James, it's always a pleasure having you in the studio to try and unpack this for us. Let's perhaps begin by what this judgment actually means for every individual who may be interested in, is already using, is already growing marijuana. What does this mean?
So the judgment makes it lawful to possess, to use, and to cultivate marijuana for one's personal use in private. And that's effectively the bottom line. If you want to use or possess it, you have to grow it. You cannot buy it. You cannot sell it. Your only means is to grow it yourself. And you do need to grow it yourself. You can't have somebody else grow it for you. And if you are to use it, you must use it in private, and you can only use it yourself.
Are there disclaimers of what in private means? You know, is in private at the pool around the complex? Is it in my house? Is it in my estate?
The judgment is unfortunately less than clear on that, except to say that in private goes beyond being in one's private dwelling, so that the court, in talking about, for instance, the possession of it, if one were to possess marijuana by having it, say, in your pocket, and you were to leave your home with it in your pocket, it would still be within your private possession. That's about the greatest clarity that we have on privacy beyond one's home. There also seems to be lack of clarity on whether privacy necessarily extends to being within your home. Because if there are members of the public in your home, or friends even in your home, does that mean that your home is no longer private? It's unclear.
All right. Does it say whether or not you can share, now that we're on the issue of friends? So if you have friends coming over, do they have to bring their own homegrown marijuana, or can you give them some of yours?
I believe, on my reading of the judgment, that if you were to give them some of your own, you would be crossing the line into dealing, which is strictly prohibited. They would have to bring their own, which they grew for their own personal use.
All right. Well, it seems like there's still going to be a lot that we need to understand around the implications of this judgment. Let's talk about the issue of then law enforcement officers. If you are caught by the cops, the discretion is up to the cops to decide whether or not the amount which you're in possession of qualifies to actually take you behind bars. Maybe clear those muddy waters for us, James.
I have to throw up my hands at this point and say I can't, and it's a most unfortunate part of the judgment. Justice Zondo and the rest of the court were right that there is this discretion in our law in respect of many offences, but regrettably when it comes to this particular offence, it's ahistorical to take the view that police officers can be left with this discretion, because they've historically abused it. When they want to arrest somebody, this is the exact offence that they pin on somebody, that they are either in possession, and now it will be that if they are in possession, that they are in more than, or whatever possession they're in is for the purposes of dealing, and so they will arrest the person on that basis. It's wide open to abuse, and it's most unfortunate.
Let's talk about then also part of the work that still has to go through the legislative arm of government. The Court has set down 24 months, but practically, James, how long is it going to take, firstly, to, I suppose, ensure that South Africa is no longer part of any of the statutory international agreements that we are signatories to when it comes to the regulation of drug use, and Dagga in particular? And secondly, for Parliament to actually reach some kind of consensus on policy and regulation?
The 24 months run from when the Davis judgment was handed down, which is, I think, November or October of last year. So there's effectively 1 year left. Is it possible, in my view, for Parliament to arrive at some sort of consensus on such a controversial issue? I am troubled. I'm very hopeful, though, that the Constitutional Court was clear that the interim relief which it gave, which is to the effect that although the provisions are not invalid immediately, the Constitutional Court instructed that the sections be read as if they have been amended for present purposes until Parliament amends the sections. And if Parliament fails at the end of its 24-month period, which is roughly in 12 months' time, those amendments that are to be read in will become permanent.
So does that mean that there is no stay of prosecution here? Does it mean that technically what the Concourt has allowed in terms of possession, use and cultivation is in effect from today on?
It is in effect from today on. It is in effect going back to the moment that Justice Davis handed down his decision. But here's a caution, it's only in effect from that moment on and not before that. But importantly, your viewers will want to know that it's in effect now.
All right. Very briefly, lastly, James, what happens to those that have been arrested for possession of marijuana in particular in effect of this judgment, in terms of the Davis judgment, as you said,
yes,
in November last year? Does this mean that their cases could be thrown out of court?
Yes, so long as they were in possession for their own personal use in private, and that this happened only after the Davis judgment, their cases must be thrown out.
All right. Well, certainly they'd have to prove that these were indeed the circumstances under which they got to possess the Dagga. So there we have it. Thanks for that clarity, Dr. James Grant.